Okay, chapter 18. I got to turn my screen on again. This will be real quick. Why do you want to record a title? Why do you record a deed? What's the method? What's the reasoning? Why do we want to record? Constructive notice. You give, literally, by recording something, you give notice to the world that it exists. You all, most of you in this class are too young to remember, what was one of the ways that we used to give people notice? We published something in the newspaper. Today, people never read that legal, I don't even know if the legal section, I think it still exists. You still have to do it by some laws. But most of you all would never read the newspaper to get a legal notice. Why would you do that? Believe me, it was 20 years ago, and that's where we were looking all the time for legal notices. So we would tell people, by publishing in the newspaper, we did our part, literally, to tell our neighbors. It didn't matter whether they read the Inquirer or the Post. We were telling our neighbors that we were going to do something illegal, giving legal notice. I live in a neighborhood, there's little bulletin boards on certain streets where they put the legal notice for the neighborhood meetings and stuff. My daughter-in-law walked by one day and she said, "What's this?" I said, "That's our legal board." What do you mean? That's where we give notice. We still do it. It's old-fashioned. Yes, we have a web page, but they still put the dang thing up there. And so we record and we give notice, and there's a way that we have to record when we're doing things in the county. So we have statutes that tell us we have to record. These are laws that require the entry into the books of public record, the written instruments affecting title to real property. So anything that's going on with real estate has to be recorded, to be done, to be completed, recorded, done. But we find all kinds of exceptions, right? Okay, acknowledgements. A formal declaration by the person who executes an instrument that he or she is freely signing it. Signing is attested to by a public official, usually a notary public. So when I notarize something, I want to see your ID. I want to see that you are who you say you are, and I'll ask you, are you doing this of your own free will? And then I let them sign. That's really all I got to do as a notary. I don't care what the document is. I don't even look at what the document is. I just make sure I'm writing their name right, and I'm notarizing in the document where it says I should do it. Legal notice. It's a knowledge of another's interest in real property sufficient to make the adverse interest legally binding on the prospective purchaser and any other party acquiring interest in property. So, any purchaser doesn't know how to go down to the courthouse, doesn't know how to go through legal records to look up this information. You should try it sometime. It's very interesting. But that's why we hire title companies. We let the title companies, they're our professionals that go do this for us. The actual notice is title information that is acquired personally by the interest holder. Implied notice is legal notice that is imposed by the law when the conditions exist that would lead a reasonable person to inquire further into the condition of the title. And constructive notice is the knowledge of certain facts that might be discovered through a careful inspection of public records, provided that such information is within the history of title or discoverable through an inspection of the premises. So again, actual, implied, constructive. You need to understand a little bit of a difference between the three. Your textbook does break it out. What do you need to know about legal notice? We employ, as realtors, we employ title companies to go research the legal records for us to see what's recorded against our properties. What are the kinds of things that are recorded? Our deeds are recorded. Easements, and that's the biggest piece. That's the thing the title companies are looking for. When you buy title insurance, the title company will say, we're guaranteeing your title except for these things that we found. These things that we found are the public record, are the easements of record, are things like that. As a title company, we won't cover your easements of record. We tell you they actually exist and why they exist, and we don't cover them as part of title insurance. We actually make an exclusion to the policy. Why? Because they're necessary. The easements run with the land. It's somebody's ability to go on and off land, cross your land for utilities or whatever. But those are exceptions to title policy. Types of recording statutes. Ohio is what we a race to notice statute. Statutes that provide a subsequent buyer who has no notice of the prior transaction at the time of conveyance and records first will prevail. So where the race to notice statutes happened in Kenwood with the big tall building on the hill, they didn't record the mortgage for a month. But the vendors, lien holders, electrical contractors and stuff filed their liens before the mortgages got recorded. So they became race to notice. They got first priority over the mortgage. But this is why your mortgage company says the afternoon of the signing or the next day of the signing, they literally want somebody to go down to record the mortgage, to put it in records, because Ohio's race to notice. Notice statutes that provide that the subsequent buyer prevails over all interested parties who have not recorded their interest at the time the buyer accepts the conveyance and pays consideration for land without notice of the pre-existing conveyance. So part of this is we're trying to protect the public from somebody selling their property twice or 3 times or 4 times. It happens. People do fraudulent things. But this, by providing notice, somebody could go do some research. So what does this do for a cash buyer? Because cash buyers aren't usually getting title insurance. They're not looking. What should a cash... Okay, you represent somebody as a cash buyer. What should you be telling them to do? Not only get title insurance, but maybe they should do a title search before they close. Do a title search. Because buy title insurance, well, the company's going to go do the title policy, and they're going to say, well, you should have known about it. These are exclusions. So what you want to do, if you're working with somebody who's a cash buyer, do a title search before you get to a closing. Have them do that first piece. And the title search is usually $500 for title commitment, where they go do the search. That's a peace of mind for any cash buyer, is to have that, at least get the title commitment done. The recording process, chain of title, the recorded history of events that affect title, specific parcel of land, usually beginning with the original patent or grant. So we talk about the chain of title being a consistent chain, no broken links of the title. Chain of title has to be consistent. When the chain of title is broken, very often that means we're missing documents. We're missing deeds, or we're missing mortgages that have been fully satisfied. There's things that are going on with the title search. Mistakes in recording or errors made by the recorder. If there are errors made by the recorder can be liable. They buy insurance for what they do. They can be liable for those errors. So usually it's just a quick error, and it's a matter of making a phonetical correction. But if people are harmed money-wise, then they can be held liable for that. Mistakes in the instrument. Errors made in the preparation instrument to be recorded happens. One of the things in Ohio that they do, anybody that prepares a deed, the attorney has to sign the deed. And the reason they do that is if there's a mistake in the instrument, they can go back to the person that prepared the deed. Assurance of title. We'll get an abstract of title. It's a summary of the recorded transactions, including deeds, mortgages, judgments, and the like, affect the title. We'll get attorney's opinion of title. The attorney renders an opinion based on the abstract of title. Okay, most title companies actually have an attorney that works in their title office. And very often, that person can write an opinion of title for you as well. But you really, when you're asking for an attorney's opinion of title, you want to go to a real estate title attorney that knows what they're looking at. Title insurance is a comprehensive indemnity contract that insures title holder against title defects and encumbrances that may exist. And then we have something called the Torrens system. It's a document issued under the Torrens system. It's a type of land title registration. So if you go to the county and you get a Torrens certificate, it's this big, literally big piece of paper that gets folded all up, and everything that has happened with that piece of property is written on that certificate. It's all the history of that piece of property. In order to get title work done on a registered piece of land, it's registered land, you have to hire a registered land expert. That's different than a regular title person. They have some extra training, and they're the only ones that are for lands. Any registered land is usually the Torrens system registered land, and you'll hire a registered land examiner to go look at that. When the shopping center I manage in Huber Heights in Dayton, Ohio, has over 400 pages of easements and restrictions. I couldn't read most of them. In our system, we've got some of the ones that are with leases and stuff like that, but I couldn't read most of them. So I paid Chicago Title $425 to give me about 400 pages of documents. Guess what? One of the first 2 things I did, I found 2 pieces of property that we weren't getting money paid for that we should have been. Prior owners didn't go back in and enforce easements against adjoining property owners that had the right to drive across our driveway, but they're supposed to pay us easements. It was all there, but they didn't go do that. So so far I've gotten over $3,000 for my $400 investment by actually being able to read documents. And I haven't even had time. Those are the ones that are very obvious. I haven't gone into all the documents yet. Next thing, one of these days, I'll have time to go through 400 pages and actually put them through the machine and copy them somewhere and get them indexed somewhere with the property. But prior owners didn't care to do that. So the more involved your property is, the more it makes sense to get some help to go do this. I knew that there was no way I had time to literally go to Montgomery County and pull everything that had to do with that property. It was much cheaper for me to pay somebody, a title company that knew what the hell they were looking for, to go get everything. But you want to do that. Assurance of title. And that is it. Any questions? All right. I will bring Chapter 18 homework next week.